Hi guys, this is Asal. I'm studying for the bar and I wanted to review my notes with you. So far I started studying criminal law, I moved on to torts, and I'm still on torts. I'm gonna make more video on torts today. But in between all this, I would like to pause real quick and I would like to talk about legal writing. Okay, so actually this is a very important topic in law school because we have, in the first year, we have legal writing 1, in the second year we have legal writing 2, and legal writing 3 is in the last year, and that will be actually one of the last classes I'll be taking. Okay, so just recently I was asked to write a memorandum, and I just realized that I'm so rusty and it's been such a long time that I've actually written a memorandum. So I decided that I'm gonna make a quick video and I want to describe like how to write a memorandum, and I also want to talk about something that was really difficult for me to learn in legal writing class, and I think until today I struggle with it a little bit. Like I struggle with the concept of what does it mean objective and subjective. What is objective thinking and subjective thinking? So I wish someone had told me that that's actually the first word someone needs to put in my mind when I get into law school. Objective, subjective. Think both ways. So with that being said, I would like to make this video and just describe what is objective legal writing and persuasive legal writing. Like, what's the difference between the two? So, an objective legal writing is meant to be neutral. Okay, so what does that mean, neutral? For example, this means that your memorandum should evaluate whether or not a client has a claim under a particular clause of action. Okay, what does this mean? As I've said before, the law is not black and white. What does this mean? This means that there's always another argument, like here's the plaintiff, she thinks she has a claim, she goes to the law office, but there's always more to it, because once the plaintiff brings the claim, the defendant, they're not just gonna sit around, they're just gonna defend themselves. Okay, so they're gonna have defenses. So my homework is to write a very effective legal memorandum so that I can describe to my boss that, okay, let's say that, when a client comes to him and the client says, do I have a claim? Okay, they may have a claim, but when I'm making the legal memorandum, I have to think about both sides. What would the defendants say? So in my legal memorandum, I'm going to have to explain the other side's argument too. Okay? So, with that being said, we can't just suddenly think that we're completely going to win a case. That's actually something I wrote right here on my hand, and that you might not get the outcome you wish for, So, the next thing I would like to talk about is you would have to determine whether you have a potential cause of action. So like when a client comes to you, you would like to determine whether that client has a valid cause of action, and you cannot just like try to arrange the law in a way that you think that is most favorable to your client. It just doesn't work like that. So you're gonna have to think objectively, and in your memorandum, you're going to have to discuss both sides. Okay, for example, let's say that your client comes in with a claim of negligence. You're going to have to discuss, okay, whether she has that claim of negligence, and if not, what would be the defenses. Okay, because you cannot just like leave out whatever fact you don't like. You cannot just like pick and choose and be like, oh, I like this fact, I'm gonna use this. No, because when you use that fact, the other side is going to come back and say something and defend themselves. Okay, so also something else about the facts: failure to divulge a known fact and controlling the adverse law could lead to the malpractice, or under the Rule 11, sanctions. So actually right now I'm studying professional responsibility, and this replies here with the sanctions. Okay, so I would like to say this again because it's very important. failure to divulge known facts, and controlling adverse law could lead to malpractice actions or Rule 11 sanctions for filing frivolous claims. Okay, so this is very important. You cannot go around filing frivolous claims. And okay, so I would like to also talk about what it means to have a persuasive writing. So I'm not the best writer myself, I'm constantly working on myself. Writing is always a work in progress. I can always get better. I know that. Okay, but I can still talk about it and get better. What is persuasive writing? Persuasive writing is usually writing that will ultimately be provided to the court or an opposite side, okay? So your document should influence the court's view. You want to influence the court's view so that the court will rule on the law that is most favorable to your client or to you, okay, to the desired outcome. Okay, mandatory authority must be acknowledged. That's very important. And a skillful writer will learn to distinguish the adverse authority, okay, in order to diminish any potential negative impact. Okay, that's very important. The next thing I would like to talk about with the objective legal writing is that you must describe the facts and the law as accurately as possible and predict the outcome of the case, okay? Whereas with persuasive writing, you argue in favor of the client, both in describing the facts and describing the law. Okay, so that's pretty much everything I wanted to say about objective writing, persuasive writing. Just keep this in mind that you want to argue both sides, and law isn't always so black and white. So I hope you enjoyed this video. Have fun studying. Bye.